Today we're going to discuss about the trends in the adjustment of status applications, what happened with the refile cases, that when the EB2 moved forward, we refile the cases, what are the results of those things. We're going to discuss about the EAD approvals and the advance parole not getting approved even though we filed at the same time. We're going to discuss about the employer's registration for the H1B lottery. We're going to also discuss about EB3 to EB3 I-485J supplement that we started filing in the last week of January. What happened with those applications? Emily, what are the trends in the 485 application approvals? You publish an article and you keep updating those articles on your blog, and you see there is a trend that is going on. You observe the trend. What are the observations that you have on the adjustment of status approvals?
Yeah, so we're looking at average processing time at all the different service centers where one of our attorneys has cases pending from the time of filing to the time of approval. And that does keep going down. Last week it was about 293 days average, and now it's down about 280. So that's getting better. But even more importantly are what's going on with the refiled cases. So we have some people where we filed the EB3 downgrade with the adjustment of status in October 2020. It's languishing at the Texas Service Center. I-140 and EB3 finally got approved, and the final action date becomes current in EB2. Some people who were continuing to maintain their non-immigrant status decided to file a second I-485 application to take advantage of the EB2 process. And we have been seeing those being sent to the National Benefit Center, which has much better processing times. And in fact, we just got an approval in 44 days of one of these cases that was filed in December, approved in February. Second approval came in this month, was approved in not much longer than that, filed in November, approved in February at the National Benefit Center. And interestingly, they're not sending any kind of request about the EB3 485. They're just closing that administratively because you don't need 2 green cards at that point. At the same time, we had this special interfile process that was announced at the end of January, and we've been filing those as well for clients that didn't want to file a separate 485 or who are not maintaining their non-immigrant status. Not one receipt notice for those cases yet with that supplement J, not one approval yet for those cases. So at this point, refiling seems to be the way to go. We don't know if that's going to continue. Obviously, we don't know what's going to happen with this interfile process since it's brand new.
For most of the people who are refiling, Emily, they are reusing the biometrics that were already done. For some of them, they are asking. For most of them, they are reusing it. Even though their first application went to Texas Service Center, the second application that went to National Benefit Center, there are some cases where when we refiled, Emily, they are getting transferred to the Texas Service Center though. But most of the cases are remaining in National Benefit Center, and now we started seeing the adjudications of the refiled cases though. If we are not yet to conclude telling everybody that go refile all the cases, definitely we are not. We are just telling observations of these trends. It may be too early for us to make a judgment call on the 485J supplement that we started filing in the January last week. As Emily pointed out, no receipt notices, no approvals, no indication they have been transferred to any cases, no update on any of the information though. But we don't know if we starts getting the approvals, we're going to start getting the receipt notices. But as of now though, it is 2 goals for the refiling and 0 goals for the interfiling at this point of time. But we'll keep updating every week, and if you can watch the updates in the immigrationgirl.com, which is hosted by Reddy Neumann, and you can check the trends there. You can scroll down and then you can see the trends of the adjustment of status adjudications, how they are happening, which service center these cases are getting adjudicated, which service center, how much time it's taking to get approved. Is it EB2? Is it straight? Is it downgrade application? So we do publish these trends every week, so you can observe those trends though. Anything else, Emily, on this one? Before?
Yeah, also, we've noticed in some of the refiled cases, we generally file it with another EAD and advanced parole application, even if the person received the EAD and AP from the October 2020 filing. And in some of these cases, they're approving the second filing. Some of them, they're approving for one person in the family, but not another. Some of them, they're closing the second filing of the EAD AP saying you already have
Already
a
have
valid,
the EAD, valid EAD.
yeah, so we don't need to issue you another one. So it's kind of all over the place on that. Doesn't seem to create any problem for anyone because they already do have a valid EAD and AP, but just different, very inconsistent in how they're applying this.
Emily, when we're looking into the trend of the February approvals for the adjustment of status on your immigrationgirl.com, Emily, I see that most of the cases that got approved in February of 2022 were actually filed on or after October 1st of 2021. Mm-hmm. So if you look into the trend though, the applications that were received in October of 2020, they are just there, not doing anything. But the applications that have been filed on or after October 2021 are getting approved. Mm-hmm. The ones that were filed a year before are there pending, and the ones that we file later on are getting approved. So it may tend to go more towards refiling the application at this point of time. One other trend that I want to tell all the people is that we have seen a good number of cases getting transferred to National Benefit Center from Texas Service Center. We have seen some cases somewhere in month of December and January, cases getting transferred from National Benefit Center to the Texas Service Center. But in the month of February though, I noticed more cases are getting transferred to National Benefit Center than compared to what it was before. So that may be a good sign too. But it definitely seems to be not a good thing because they are not going last come, first serve. Mm-hmm. That should have been the trend though, but they're not doing it. It seems that at this point of time that there is a black hole, that the applications that we filed in the month of October and November went into the black hole, and the EADs, advanced paroles, are not getting approved, and everything is pending there that will be pending in Texas Service Center. Mm-hmm. Is there any way out for that, Emily?
At this point, based on what we're seeing in actual cases, filing a second 485 seems to be one way to get out of that, especially where the EB3 I-140 is approved. The cases, we've seen many where we do a second filing and it gets transferred to Texas, it's because the I-140 remains pending in Texas, and once that gets approved, they've been sending it back to National Benefit Center. So that seems to be one way to get out of Texas. We don't know yet whether this interfile process will get them out of Texas or whether it will speed anything up there or get things moving.
Emily, what is this trend where the EAD is getting approved and the advanced parole is not getting approved? A lot of people think that they can travel on EAD approval, which is not true at all. You can only travel when the advanced parole is approved, okay? So everybody who has an EAD approval, you check on your EAD approval if it says advanced parole approval too. If it doesn't say advanced parole approval, then that means that you only got an EAD approval. You cannot travel. You go to India, then you notice that your EAD is approved, your advanced parole is not approved. You will be stuck there, and most probably you may never be able to come back into the United States. So please please everybody who is listening to this one, we have approximately over 40,000 people listening to our different medias. If you are listening to us though, we want you to look at your EAD and look into the adjustment of status EAD, look into it if the advanced parole approval is there. If the advanced parole approval is not there, think that it is not come, so you have to wait until advanced parole. And why is that they're doing this, Emily?
There's no transparency here. There's no announcement, no kind of letting us know this is what we're doing before we do it. No clue. My best guess is they're sick and tired of people complaining about long processing times for EADs. There's all these articles in the newspaper, online, saying that, hey, we could solve the labor shortage or at least help it if we would speed up the processing of work permits. So I think maybe they've gotten the hint there and are trying to put additional resources onto approving EADs. Some of the recent ones are getting approved in 2-3 months. Whereas before, like you said, we still have cases from October 2020 that don't have the EAD AP yet. So possibly their effort is to try to get those EAD approved so people can get back to work or start working, and the travel is less of a priority for them, and they might approve those later.
Emily, anything on the glitches of the employers registering in the lottery system, Emily?
Yeah, so yesterday was supposed to be the day that the portal opens up for employers to create their My USCIS account if they don't have one already, or log into it and make sure that everything's good. And so employers started logging in to create their My USCIS account yesterday, and the option to select H1B registrant, which is what employers need to do, was not there. No news from USCIS all day yesterday because it was a federal holiday. Today, this morning, people were continuing to report that they could not access that. And then it seemed like afternoon Eastern time, it became available. So it looks like maybe USCIS goofed up and set the start date to be on a federal holiday and didn't actually open it up until the following day today.
Don't they have something like you can post it on the Facebook or YouTube? Okay, you post on that particular time. Don't these guys have that technology? Maybe they need to hire some of our H1B guys. The USCIS people need to hire these smart guys that are there, that they will do this, because these people are working for Facebook and Google and other companies. They're able to do it, but the government with such a big budget cannot do that.
Yeah, so as of this moment, seems to be going fine. Employers should be preparing for March 1st to actually submit the registrations, and that goes until noon on March 18th.
Emily, on the 485J supplement, we already discussed about it. For the people who wants to move from EB3 to EB2, we just are updating no receipt notices, no approvals, no information, nothing, because there is no filing fees involved in it. We can't have any of our checks getting cashed because we never send any checks to be getting cashed. But we will update if anything develops on this 485J supplement in the coming days. This is constantly you have to keep watching our channel. I mean, the reason why we tell is that I don't know of any other channels where every week they come and update the entire thing, what's going on. If you do, that's fine, you can watch. But our channel, in every week, we update it. Things keep changing until you get the green card. We recommend that you stick with our channel until you get the green card. Let's go to the questions and answers, unless you have some other topics to discuss.
One thing that came out with this interfile process is USCIS says, well, once you interfile, you need to wait 180 days before you can take advantage of AC-21, even though your 485 has been pending for well over 180 days. They seem to have pulled this rule out of thin air. So we would caution you that if you are doing that interfile process and considering a job change, what USCIS is saying is that you have to wait 180 days from the day the interfile request is received. Of course, we don't have a receipt notice, so how do we know they've received it? We don't yet. I don't know if this would stand up in court if someone eventually gets their EB2 denied because they ported too soon. I think that is something that could be litigated, but of course, I don't necessarily want to be the one for my client to test that theory. So just be cautious with that.
Yeah, if you want to be a little bit conservative, it's better that you wait until 180 days after it's been approved. Sorry for Rajesh and Alok, and we had some technical difficulties. And thank you for pointing out that the voice was not coming. We corrected it. Now the voice is coming. Thanks for the comment, Rajesh and Alok from YouTube. Question from Alok. I have a H1B approval stamped until September of 2023 with company A, got the approval with company B, not started working. Can I leave country and come back USA in the old approval? Yes, you absolutely can come back on company A. But one thing, Alok, is that once you come back on company A's H1B stamping, and you're also showing the company A's H1B approval, you're also getting the I-94 on the company A's 797, you can only work for company A, you cannot work for company B. That is the only condition that is there, but I don't see any problem in you traveling though. Question that came there is, if I move to a different company, can I still interfile from EB3 to EB2? Yes, you can, but the new company need to have an I-140 approval. You cannot use company A's I-140 approval with company B's 485J supplement to interfile from EB3 to EB2. In other words, the company B must have an I-140 approval for you to move to EB2.
And that's very important because I'm hearing people being told otherwise.
I don't know how the lawyers are telling that we can file. We can file interfile because you can't use company A's I-140 approval. But when company B is signing the 485J supplement, they need to have the company B's I-140 approval. Now, there is a caveat here. Now, you can move from company A to company B. We are not telling that you cannot move from company A to company B. The only thing we are telling is that if you want to do the upgrading from EB3 to EB2, the company B must have an I-140 approval.
Bharat says his EAD got renewed, but in the first time they did it, he got the combo card, but this time it's only the EAD. What's happening? How do I get my AP? Because I want to travel soon. Yes, we are noticing the same thing in my cases as well. First time came on a combo card. This time around, everyone assumes once it's approved, we'll get the advanced parole with it, we can travel, and then the card comes in the mail. Oops, it's only the EAD card. Seems to be the new trend. Again, we think it's because USCIS is trying to prioritize the EADs so people don't lose their work authorization, but people also need to travel. What can you do to expedite it? Your options are basically, if you fit any of the expedite criteria, such as a humanitarian need to travel, you can try calling the 1-800-USCIS customer service number and sitting on hold, trying to talk to a live person eventually to explain the situation, then be asked to email documents in, and then hope that they actually do expedite it. But they are not approving very many expedites these days.
Momo Lee from YouTube has this question. I-140 485 filed in February 10th. It is waiting. It's in the Texas Service Center. Is it normal for not getting a receipt notice, though he filed in February 10th of 2022? Yes, it is normal that it's been almost 12 days and you did not get the receipt notice yet. Mamo, we would have a different strategy of filing your 485 if we were your lawyers, though. If your labor certification has been approved in the past 6 months, you're filing an I-140 and 485. This is how the strategy we are using right now. We are filing an I-140 in premium processing. We're getting the I-140 approval in premium processing, then filing a 485 independent application. The reason we are doing is that if we file an I-140 and 485, it will not go to the National Benefit Center. It will most probably end up in Texas, or at the most, it'll end up in Nebraska Service Center. Either of those things are not good. So that's the reason that is not a good strategy to file an I-140 and 485. Now, for those people who are downgrading though, they don't have much option because there is no premium processing allowed for those people whose labor certification was been approved for more than 6 months ago. So they've been forced to file I-140 and 485 together. But if your I-140 is fresh, I would have got your I-140 approved first and then file the 485 application.
So Robbie noticed that on the visa bulletin, there's a section D mentions corrective action that might be needed in EB2 due to EB5. And he wants to know, what is this corrective action? Is it going to be retrogression? What's going on with that? When they mention corrective action, especially given that EB2 has been moving forward, I can only imagine that they mean slowing down or moving EB2 back, retrogression for EB2, because what's ultimately happening is those EB5 green cards that are not being used spill up to EB1. They're not going to be used up by EB1, so they spill down to EB2 and eventually across to EB2 India, because rest of world is not going to use up all of those either. So if those EB5 numbers all of a sudden start being used by EB5, then you don't get that spill up, down, and across action anymore.
But don't you think so? Because of the regional service center blockage right now, the EB5 is not going to use the numbers right now. Mm-hmm. So that means that EB2 should move more forward because of it, is right?
Right. Yeah. And we don't know, did they already take that into consideration when they moved EB2 forward? Or did they move it based on the visas that EB2 normally would have without taking into consideration EB5?
Why would they throw the statement there? Yeah. The only thing is that I think so that they publish the things and they want to correct it. I am expecting the more correction to be coming forward in April. I'm expecting more forward movement because the number of green cards that are available in EB5 are not going to be used right now. The reason they're not going to be used is there is a change, or there is a law that sunset and that was over. Because of that, there is no regional center green cards. Most of the people who file the EB5 green cards file through regional centers. So they are not adjudicating the cases, they're not approving, they're not denying those cases. So those cases, because the number of green cards issued in EB5 is lesser than the number that is been allocated, we do expect more numbers to come into EB2. As Emily has all pointed out, from EB5, it goes to EB1, falls to EB2. It will eventually end up with the EB2 Indian nationals though. Also, Emily, I want to observe one of the trend though. If I look into your blog though, the amount of green cards that got approved in the month of February though, as compared to the amount of green cards that got approved previously. I mean, in the same quarter of the last year to this quarter though, of the same year of this year though, the number of approvals of the green card is very high. So they last year they wasted about 60,000 green cards. I may be expecting that if they go in the same pace though, I mean, or if they go at the same pace of what they did in the last quarter of last year, I may be expecting all 280,000 green cards to be used, which is a good news actually. If they continue doing that, they may be advancing more priority dates, because at the end of September 30th of 2021, Emily, there are only 260,000 adjustment of status applications pending. So if they adjudicate at a faster pace, we may be expecting some faster movement and maybe less wastage of the green cards this year.
Yeah, it looks like they're at least not waiting until the fourth quarter to pick up the pace. So hopefully that continues and keeps going faster. Harry says, if EB2 priority date is current, can the employer request a 3-year H1B extension, or is it only 1 year? So assuming it's the final action date that's current, on the time of filing your H1B extension, if it's beyond the 6-year limit, you're only eligible for a 1-year H1B. You're not, the 3-year extension cuts off when the visa becomes available, the immigrant visa becomes available.
Raghupati has this question. I refiled the EB2 in January 2022, got receipt notices, and he got a notification that biometrics have been reused. Do I need to withdraw the EB3 application because my attorney says I may get an RFE or may reject EB2? No, we're not seeing that trend, Raghupati. We're actually seeing EB2 getting approved. In fact, the cases that we even filed in December got approved. The cases that we filed in November got refiled approved. They are just administratively closing the EB3 after they approve your EB2. That's a trend we are seeing. At this point of time, I do not want to withdraw the EB3. One problem that I have with this withdrawal of the EB3 is, what if they get confused and they withdraw the 485 EB2? Then you will be na garka na gatka. I'm sorry to speak in Hindi, but that will be a problem. I will definitely will not withdraw right now. The trend seems to be approving. If ever they issue an RFE, I'm going to respond, but I will not voluntarily withdraw the EB3.
VK has an H4 and H4 EAD extension pending with USCIS and wants to know what happens to them if I go for stamping before getting the approval from USCIS. So you can do that, assuming that your spouse has the H1B extension already approved. Once you get the stamping come back in, your H4 extension can continue to be processed and the EAD can continue to be processed. Most of the time it does. The only issue that comes up is your H4 approval might come with your old I-94 on it. The number will change when you enter on that H4 visa stamp, but it doesn't update automatically. So you may have to send in that I-94 to get the correct number on your H4 approval notice. We've had maybe 1 or 2 cases, very rare, but they have administratively closed the H4 extension because they said you don't need it. You have the visa, you got the I-94. That's fine, except that caused the EAD to be denied. But again, that's only happened once or twice, and it has not happened that I can have seen within the last 6 months, so that they seem to have fixed that problem.
Zulfikar from Facebook has this question. My employer is sponsoring a H1B. If I get picked up, can I complete 2 years of STEM OPT and then go for the H1B stamping? I do not advise you to do that, because technically if they approve the H1B in the consular processing, you're not counted towards the H1B number. What if you lose the job? What if there is a COVID and you can't go for stamping? No, all things can happen, guys. If you are an F1 and if you get an opportunity to file a H1B by the company that you're working on, go for it, get the H1B. Don't wait for the second term, don't wait for the term, go ahead with the first term. I do not, you can always apply for the green card and get it better, but remember there are a lot of people who apply first time, don't get it, They apply second time, don't get it. They apply third time, they don't get it. And they go to other alternative methods at that point of time, which are very dangerous, not advisable. Now, since you are getting the chance first time, go for it. If you get the H1B, go for the transfer. Don't try to use up the entire 2 years of the STEM OPT.
Prasad says, my EAD is pending since October 2020. No response with service requests. What can I do? At this point, I think litigation is probably your best option. That has been an option for interim benefits, those that you get while your 485 is pending. You can reach out to our office. Stephen at rnlawgroup.com is handling those types of cases.
Cool logic. I've been a manager in Canada. I've been managing role for more than a year. This summer I'm pursuing EB1C. Do I need to have a direct reportees for the US to begin in the EB1C or L1A category? Yes, you need to have a direct reports in USA though for you to be eligible. Because if you're just showing everything in Canada, your prospects of getting an EB1C or L1A will be very, very less.
Abhishek says the primary applicant received the EB green card, but dependent got an RFE. By the time it was responded to, the priority date retrogressed. Given that the dependent cannot upgrade to EB2, is there any option other than to just wait? You know, we've been seeing this more and more commonly, that the main applicant and the dependents are being separated, and the main applicant gets approved and then the dependents get stuck waiting a while. But even worse is the situation where the priority date retrogresses. So if you do, one option is the family-based green card process as a spouse of a green card holder. In that category, you could file an I-130 and a new 485 under the family-based category. But you have the problem that your spouse is no longer maintaining non-immigrant status. So that might have to be something that's done via consular processing. Not good options all around, but there's nothing that can be done with this 485 until the priority date becomes current again.
Neelima has this question. I'm planning to relocate. Can I file the 485J supplement with a new location? Different location mentioned in the poem. Absolutely, you can. The first is, Neelima, are you filing the 485J supplement for what reason though? If you just change the location with the same company without upgrading to EB2, there is no need if whatsoever at all for you to file a 485J supplement. Only in cases where you change the company, you need the 485J supplement. You may need the 485J supplement if you're upgrading from EB3 to EB2. If you're moving from Florida to California and you and with the same company, you don't need to file a 485J supplement. Newton from YouTube has this question. I have used the EAD AP that came from EB3. I traveled to India, came back without H1B stamping and advance parole, I guess. Will I be eligible to file the interfile into EB2? Absolutely you can. Absolutely you can. You are eligible to interfile. For refiling the 485 application, you need to be on non-immigrant status. For interfiling, even if you use the EAD and advance parole, you don't have any problem. For those people who are filed EAD and who have used the EAD and advance parole, if they want to refile the application, there are other methods of. You can always go out to Mexico and come back if you have the 797 of the H1B. There are other methods if you want to refile. For interfiling though, you do not have to maintain the non-immigrant status.
Zane says, is it required or optional to inform my H1B sponsoring employer if I marry a US citizen and my spouse files the I-130 and 485 for me? I think the filing of the I-130 and 485 is not relevant to your employer because you can continue your H1B status after that is filed. But once you get your green card, you should let them know that so that they don't have to continue to maintain all of the H1B documentation that's required anymore.
Krishna Chilkuri has this question. His 485 interview is done on November 5th, 2021. Still did not get the green card. How long it's going to take? The first thing I'm assuming that is that your final action dates are current. If that is current though, it could be on the same day that you got the interview, and sometimes they may take up to 6 months though. But if it processes more than 6 months, I would request you to contact the Ombudsman's office to get your 485 adjudicated though. There is one of our colleagues called Avery. He just went to San Diego today for the interview. He got this, some of our lawyers go for the 485 interview with the clients. He got his green card approved. His client got a green card approved the same day, then and there itself. But sometimes they take long time to adjudicate. But if it crosses 6 months, I recommend that you do go and contact the Ombudsman's office.
Srilathi traveled during the H1B extension, and when coming back at the port of entry, they only gave the I-94 till the existing visa end date, and now the extension has been approved. Do I need to correct this new I-94? It is a good idea to travel one more time and re-enter using your extended H1B approval notice so that you'll get another new I-94 number that's valid till the full period of your new H1B extension approval.
Rajni's kid age is locked under Child Service Protection Act in July. I think so, July 2000, and the priority date is July 2013, and age got locked. Is it advisable to refile under the EB2 right now, even though the priority date, the final action priority date, is not current? Rajni, the answer is clearly no. Don't refile if the final action date is not current. Now, this is only because Rajni's kid is coming near 21, guys. So that's the reason I'm advising Rajni not to refile the entire 485 application. If you may evaluate your circumstances when the final action date becomes current for the EB2 to refile the entire application. But for now, my strict advice to you is that do not refile and do not interfile right now.
Rajan says, what is the timeline for an EB1 green card approval? Well, today I received one that I filed a year ago, and yesterday I received one that I filed 2 years ago. So it's anywhere in between. It could be longer, could be shorter, depending on whether your I-140 is already approved or you're filing concurrently. In those two cases, the one that took 2 years, the I-140 and 485 were filed concurrently. The I-140 was approved in about 8 months, and then the 485 just languished at the Texas Service Center for another, over 12 months, 16 months before that got approved.
What's happening at Nebraska Service Center? Well, it's not as worse as Texas Service Center is, but it's very close to Texas Service Center, though. Definitely the National Benefit Center, which if your file number starts with MSC, that's where National Benefit Center is, you're in a good shape. But Nebraska Service Center is, very close to the last, which is Texas Service Center.
Newton says, if I use my EB3 EAD AP combo card to enter the U.S. without an H1B stamp, would I still be eligible to interfile?
I did take that. Balu from Facebook has this question. How many months can one stay outside USA and advance parole? If you are the dependent, though, I would say if you're going 4 months, it's fine. If you are the main applicant, if you're going 3 months, that's fine. But if it's crossing that time, I would strongly advise that you consult a lawyer before you take any steps.
Pujita says, I have a big bundle of H1B and H4 approval documents. Do I have to maintain them, or soft copies are enough for future references? I think the current one you should have the original for, but all the prior ones, I don't see any need to have the originals of those.
No, you don't need that. And that question raises up many times, Emily, right now. People are going for stamping. We haven't noticed any problem when people are going with Xerox copies when they lost the originals, especially in the stamping, and also when they're coming into the when they're entering into the country. Though we don't see any problem in them getting into the country with a Xerox copy of the approvals. Now that doesn't mean that we're telling you to throw away the originals, but it's okay if you don't have it. Prashant Kumar has this question. If they use up all 280,000 green cards by September, what's the expected priority date to be current? Definitely I'm expecting that if they use all the 280,000, we may see some movement on the priority date. It may even cross January 1st of 2015. That's my expectation. Because when I look into the amount of green cards that are pending with USCIS right now, especially they only give the data until September 30th of 2021, they have only 260,000 green cards. Out of those 260,000 green cards, believe me guys, there are about 50,000 of them that are pending forever. The reason is that they have some criminal history, they have some other issues, they've been pending forever. USCIS used to publish the data until 2018, how many number of 485s are pending, what category they are pending, when is their priority date. They stopped publishing since our old president, the president who, President Trump was there, they stopped publishing it. We requested USCIS to publish again, we filed for information, we did not get it. They're not publishing that record though. So we don't know out of the 260,000, how many are redundant. I mean, they will never get adjudicated because they have some criminal history or other problems with them. But if they adjudicate the 280,000 green cards though, we should have some advancement in the priority date. That is our expectation. And don't forget that, Emily, that we may get some extra green cards that are not used in this year, starting from October, because consulates are not fully functional, and especially when it comes to the family immigration, they're really backlogged.
Mm-hmm. Nalima says, I'm planning to relocate to a different location soon. Can I interfile with the new location on the 485? Same role, but the new location was not mentioned on the perm. Only if that new location is in the same metropolitan statistical area.
Wait, for interfiling.
For interfiling, because wouldn't that be the same as AC-21?
No,
right?
no. You can do it. You can do it without that too, because they already crossed 180 days, Emily.
Right, but you have to qualify at the time you're doing the interfiling.
I don't.
They're saying wait 180 days for AC-21.
Yeah, but they didn't say anything about the geographical location.
But that's the same thing, because AC-21, you use that to change work locations.
I may disagree with you on that.
I think you should wait.
Yeah.
Because your perm is not for that work location.
Does EB1 processing the same pace of EB2 and EB3? Is it faster? For the 485s, though, we do notice some improvement, is right, Emily? For the EB1s are much faster than EB2 and EB3.
Maybe. It depends on the month. Sometimes it seems like they're going fast, and sometimes, like I said, I've got several that are taking forever.
Especially, it makes a lot of difference, Emily, when I see the adjudication of the EB1s, if we have filed them with the I-140 as compared to without I-140.
Mm-hmm. Yeah, that definitely makes a difference.
Predictions of the priority date. Guys, I already did predict it, so please don't keep on asking the same thing again and again, though. My 20-year-old son have F1. Can he renew his H4 also? No, Manjushri. Once he's an F1 though, if you want to renew it, you have to transfer from F1 to the H4. That's not advisable when he's 20 years old. What do you say, Emily?
Yeah, I don't see any need to do that.
Yeah.
Subramaniam says, during the cap gap, can someone work for any employer or only the H1 sponsoring employer? There's no requirement that you only work for the H1 sponsoring employer. If it's the cap gap of the STEM extension, then you do need to work for an employer that uses E-Verify and make sure you're working at least 20 hours per week and have the training plan and all those things, but it can be any employer.
What is the risk of AC-21 if 485 is pending more than 180 days? Priority date is July 2014. We don't see any risk if you use the AC-21 and move to a different company. Emily, how many times have you seen AC-21 485J supplement getting denied though?
Zero.
Let's
hope that trend continues.
A lot of people are very paranoid when they want to move from company A to company B. Ashutosh, this is for you. And they're very paranoid to see any denials. As Emily has pointed out, she has never seen a denial. I've never seen a denial. Never seen a denial where people have filed an AC-21 and get the denial though. Never.
And AC-21 has been around for 20 years. It's just the supplement J that's
came
been
in
around.
2017,
right.
But AC-21 has been there from 2002. We've been doing AC-21 from 2002. Never a denial. I have to tell that there's one exception though, Emily. One guy was working as a restaurant manager and they issued an RFE on it, and we are unable to justify because his original position was a software professional, and he applied for a liquor license stating that the only thing that he does is a restaurant manager, and that for that AC21 moving the job, that is the only exception. If people moved and people ask, I'm in Java, now I'm working in SAP, will that be denial? No, you're still in the software profession. We don't see any denials in that thing either. As long as your profession is the same, we never see a denial. But yes, if you're working as a software professional, you move as a restaurant manager, definitely you have a good chance for the 485 to be denied.
Moralidar says the EB3 downgrade was done and the kid's age got locked. Now if I interfile EB2, will the EB3 child age lockout still be valid? Not necessarily. You have to re-look at that Child Status Protection Act calculation to see if your child's age would be locked based only on your EB2 I-140. So you look at the first date of the month that the final action date becomes current for EB2. What is the child's age on that date? If it's under 21, fine. But if it's over 21, then you subtract the number of days the EB2 I-140 was pending. It has nothing to do with the EB3 I-140 or the number of days your 485 was pending. That's irrelevant. If that brings it under 21, then their age should be locked. But we don't have any guidance on this. So we're assuming that the interfile, once that is received, should be acceptable for locking in the age.
Pratmu has this question, how to include children under EB2 petition of the primary applicant. If you have not already included when you file the 485 application, if your filing date or final action date is current, you can just file the 485 application indicating that the spouse or the husband, the father or mother have already filed and he is the primary applicant. I put a note when that the parent has already filed the 485 application, and they do accept the 485 applications, even though you didn't include them at the time when you filed the 485.
Pethan says the EB3 485 has been pending since 2020, planning to refile a new EB2 485 based on the EB2 I-140 approval. Can I leave the employer after filing the EB2 485 within a month and use EB3 AC21 with the new employer? Technically, yes, but you're very likely going to cause the EB2 485 to be denied because you didn't wait the 180 days from filing the EB2 485. So there is some risk there, but you could do that if you were okay with staying in EB3.
Yeah, I wouldn't do that. I'll wait for 180 days. Aslam Syed has this question, H1B concurrent filing for 35, can we do 40 hours a week? Yeah, you can. 80 hours a week is definitely a normal thing to people, for young people to work. I do work a lot of hours, and especially when I was young, I used to work 80 hours a week. So there's nothing wrong with it, you can. For all the concurrently filing H1Bs though, those people who are not aware of, if you're working for company A full-time on H1B, without informing company A, you can work for company B. Absolutely, you can. And that is called concurrently filed H1B. We normally advise people to have the company B put the hours as from 5 hours to 40 hours. In that way that you don't have much problem though. It will give a range from 5 hours to 40 hours. In that way, you will have a lot of discretion of working 5 to 40 hours. So that is the best approach that we normally advise if you're filing concurrent. So you can have 240 hours or 140 hour. Second one can be 5 hours, 10 hours, 15 hours, 20 hours, or second one can be 40 hours too. Nothing wrong with it. As long as you pay taxes, you're good. And make sure that the second company, when they're filing H1B, they should file it as a concurrently filed H1B. How do they say it? On the I-129 form, it asks very clearly, is it a change of employer? Is it a change of status? Or is it concurrently filed H1B? That means that you'll be working for one main company, this is the second company. As long as you click, you're in good shape.
Saikat says, how can I process my green card from India? I'm in India and my EB2 date is June 2014. that becomes current, what should I do? Well, one option is to consular process your green card, assuming that the employer that filed that I-140 back in 2014 is still offering you that job. If the I-140 did not specify consular processing at that time, your employer needs to file an I-824 application to request that USCIS notify the National Visa Center that your I-140 has been approved. That's taking a year to process. Once that gets approved, then the National Visa Center will reach out to you to submit your visa application at the consulate and provide your documents to the consulate. Then they'll send a notice to have you come in for an interview for the green card at the consulate. That may take another year based on how things are going at the consulates right now. So it's a much longer process, but that is an option. Otherwise, come back on H1B and then file the adjustment of status, again, assuming that job remains available.
Question. My prior to date, this is from Venkat, 421. My prior date is July 2011, EB2 to EB3 downgrade, 485 still pending, and it is Nebraska Service Center. Uh-oh, that's not good. Should I interfile or wait? At this point of time, Venkat, we are recommending to wait. You can keep coming to our channel every week. We may change our opinion as things go, because the cases that we interfile, not a single case have ever been approved. So not a single receipt notice, no action there at this point of time. Since your final action date is current, both in EB2 and EB3, in this case, since you filed the 485, there's no reason for you to interfile. Now, if we started noticing the interfile things that we did in the last week of January, they started pulling and approving left and right, like the way the National Benefit Center is doing with the applications, then we may change our opinion. But at this point of time, no, don't interfile.
Raj says, how does career progression in the same work stream impact an already approved I-140? I think it mostly depends on the immigration attorney that's advising your employer on what that
But Emily, if
is.
the immigration lawyer is from Facebook, Google, Apple, Tesla, these top 10 companies, though, they are fine with it. It's only these mediocre law firms that don't know what they're doing. They're telling them to refile the entire labor and I-140.
Mm-hmm.
When I see them, people working for Microsoft, all the FANG companies, though, when they're promoting, though, I don't see them advising them to refile the entire labor certification. But these mediocre law firms are telling they want to make money.
Mm-hmm.
What do you say?
Yeah, oh, I agree with you. Yeah, I think, generally if it's not a material change, it doesn't invalidate that labor certification, and USCIS recognizes that, especially when your process for the green card takes 10 years, there should be some kind of career progression there.
But the standard they look into, Emily, for the H1B looks to be completely different than that of the I-140, though. Let me ask you this question. Because of the progression in the jobs, have you seen any 485 getting denied?
No, I do have one I-140 notice of intent to deny on that issue.
Okay.
But I've not seen a 485 denial on that issue.
Have you seen any I-140 denials?
Not yet, knock on wood. Hopefully that continues.
Out of all the I-140s, we worked only one RFE. Okay.
Mm-hmm.
Kareem has this question. What is the most common reason for RFE for I-140? What are the chances of approval after I-140? Kareem, the most common reasons we see for the I-140 is the ability to pay, though. This comes in, let's say, for example, if your prevailing wage is $100,000, and if you're not working for that company, though, that's when we see an RFE asking the company, hey, does the company has the ability to pay $100,000 for it? Does the company have the profits? They may also look into, we want to look into all the I-140s that you filed, all the salaries that you're paying to those people, and all the prevailing wages to see if you have the ability to pay for everybody in your company. That is the most commonly seen RFE, though. Now, when a lawyer is filing a I-140, though, the lawyer should be able to easily advise the company whether they have the ability to pay, though. So very less we see the denials if the lawyer is good. Especially if we have a very good lawyer, his name is Ryan Vick in our office. That guy can scan through the things, and all he does, he files like 4 or 5 I-140s a day, I think, so somewhere around that. And then he's very good in that. He scams through. If I have a question, I just go to him, and then he goes through the income tax returns of the company, and he just can tell me whether it's going to be approvable or not. And mostly, though, when we respond to the RFEs, we get the approvals. And if by any chance we see that the company is not meeting the requirements of ability to pay, the company lawyer can recommend to withdraw some of the I-140s to make room to make sure that all I-140s will be approved because of the ability to pay.
All right, well, I think we're out of time for today. Thanks so much for joining us. Remember, we do have a daily conference call on Zoom that you can join and get your questions answered there. And you can subscribe to our newsletter at rnlawgroup.com or subscribe to my blog at immigrationgirl.com.
Don't forget that if anybody wants to make an appointment, you can go to RN Law Group and make an appointment with me, Emily, or anybody in our office. And if you have a 485 interviews that are coming scheduled, though, you may contact our office to accompany you to go for the 485 interview. Even though we have not represented you in the 485 application, we can represent you in attending your 485 interviews. Thank you.